Good afternoon, my favorite fifth grade students. This is Mrs. Como, your library teacher. Thank you for joining my lesson today. What is copyright and why does it matter? As students in the digital age, digital information is woven into your learning on a daily basis. At times, you are authors and creators of completely original works. At other times, you search through online resources, use them to answer questions, and share the information that you find. While online resources provide you with the wealth of knowledge, it is important to know how to respect the work of others. In this lesson, you will take away knowledge, tools, and resources that plainly explain the rules of copyright so that you can follow them. A copyright is a law that gives the owner of a written document, musical composition, book, picture, or other creative work the right to decide what other people can do with it. Copyright law in the United States is found in federal laws enacted by Congress. The current copyright law is the Copyright Act of 1976, Title 17 of the U.S. Code. The basic rule of copyright is that every creative work has an invisible "No Trespassing" sign on it. This does include work created by other people, but also work created by you. Have you ever written a poem for your ELAR class? Ever submitted a story you've written in Google Classroom? How about turning in a drawing or other artwork you created? Maybe for a school art show? You own the copyright to each of these automatically. So what does this mean? As the author of these pieces of work, you alone have the right to do any of the following or to let others do any of the following: make copies of your work, distribute or hand out copies of your work, perform your work publicly, let's say if it's a play, a film, a dance, or music, display your work publicly at an art show or on the internet, for example, and make derivative works, which means using your original for inspiration to create something new. When we talk about copyright rules, there are some key words that we want to be able to define: copyright infringement, fair use, public domain, and derivative work. Let's start with copyright infringement. This is outlined in Section 501 of the United States Copyright Act. Copyright infringement occurs when a copyrighted work is reproduced, distributed, performed, publicly displayed, or made into a derivative work without the permission of the copyright owner. Individuals found guilty of infringement copied too much in terms of quality and importance from the author's original piece. The two works are too similar, and an audience could see those similarities. As you can see, the wording creates a bit of a gray area when it comes to determining if infringement has occurred. Too much. We're going to look at that a little bit later as well. Fair use. Fair use is the right of the public to make reasonable use of copyrighted material in special circumstances without the copyright owner's permission. The United States Copyright Act recognizes that there are some instances when a copyrighted work may be used. Here are the 4 factors to consider: purpose, nature, amount, and effect. The purpose of the new work is informational and educational. The new work must be very different from the original. This includes criticism, commentary, teaching, research, and news reporting. Nature. The nature of the original work is based on fact or nonfiction. Items like poetry, films, artwork, and music are more often protected in courts. The amount. In order to apply to fair use, you can't use the full work. You can only use portions of the work, and you can't use the heart of the work. It shouldn't include the most recognizable part of the film, book, etc. And finally, effect. You cannot negatively impact the creator or their original work. When you use their work, it shouldn't be in a way that would make them earn less money. Whether or not a fair use has been made of a copyrighted work is not always easy to determine, and there have been many lawsuits to determine whether or not a use is fair. When in doubt, get permission. Let's talk about public domain. The public domain contains works such as books, films, or paintings that are not under copyright protection. Works that are in the public domain belong to everyone and can be freely used without paying the authors. One reason that a work might be in the public domain is that it consists entirely of information that is commonly available. Derivative work. A derivative work is a work that is created based on at least one other work that already exists. It is the right of the author of an original work to make derivative works. The United States Copyright Act gives many examples of derivative works. One example is a motion picture based upon a book. Fun fact: if you do it right, first get permission from the original author before creating a derivative work, you can then obtain a copyright covering the new original material you contributed. You're the author of that derivative work. Awesome! Let's take a look at weighing the scales. Has permission been granted? What's the difference between being fair or infringing? Some people like to play fast and loose with the doctrine of fair use. The truth is, there are no set rules to distinguish between what is fair and what is infringing. Using the 4 factors of fair use as their guide, courts have to make decisions on a case-by-case basis. In short, it's impossible to know how a court will rule. Interpretation, after all, is subjective. The best policy is to ask for permission to use the copied material you plan on using. It's not worth the risk just to cut corners. So how do you get permission? Step 1. We need to know who is the copyright owner. Publishers or distributors can give you this information, and the Copyright Office also keeps public records. Step 2 is to contact the owner. And step 3, in some instances, pay a small fee. If you're not trying to make money, though, the owner may give you the rights for free. Good question. Wanted to show you 2 of the questions I hear most often. First, how many words can I copy from someone else before it's considered copyright infringement? Remember, individuals have been found guilty of infringement by the courts for copying too much in terms of quality and importance from the author's original piece. But it's a very gray area because no exact number is mentioned. Don't chance it. Get permission. Do copyrights last forever? They don't last forever, but they do last for a pretty long time. According to current law, copyright begins at the time the work is created and lasts until 70 years after the author or artist passes away. Let's take a look at a mind-blowing example. If a college student who is 21 in the year 2021 writes a story that year and dies when he is 90 in the year 2090, the copyright will not expire until 70 years after 2090, in the year 2180, which is 159 years away. So how does something go from copyright to public domain? When the term of a copyright expires, meaning it's finished, the work falls into what's called the public domain. Remember, works in the public domain, anyone can be used without permission of the original author or artist. Feeling inspired? Like we said, copyrights do expire over time. Thinking about picking up a paintbrush, writing a love story, composing the next great symphony? You can find inspiration from artists like Leonardo da Vinci, writers like Shakespeare, and music writers like Mozart as much as you want. Their works are no longer protected by copyright. They are part of public domain. So why does copyright really matter? The overall goal of copyright laws and fair use is to encourage the production of new creative works and to create an open forum where creators are respected and protected and their work celebrated. So go out there, create, make something brand new. And if you do borrow inspiration from another's work, get their permission before you publish that derivative work. It's okay to be inspired, but remember, always give credit where credit is due.